I never imagined that buying my dream house in suburban Phoenix, Arizona would turn into a legal nightmare that would consume 3 years of my life. But the moment Sharon Pemberton knocked on my door with that fake smile plastered across her face, I should have known trouble was brewing. My name is Ryan Vance, and I had just closed on a beautiful 4-bedroom home in the Saguaro Heights community back in March 2023. The neighborhood looked perfect with its manicured lawns, desert landscaping, and mountain views that stretched for miles. I was 32 years old, recently promoted to senior project manager at a tech company downtown, and this house represented everything I had worked toward since graduating college. The HOA seemed reasonable enough during the home inspection period. The monthly fees were $150, the bylaws appeared standard, and the property manager assured me the board was professional and fair. That illusion shattered exactly 2 weeks after I moved in. Sharon showed up on a Tuesday morning while I was loading my car for work. She was maybe 50 years old, with highlighted blonde hair cut in that specific style that screams, "I demand to speak to your manager," and oversized sunglasses perched on top of her head despite the early hour. She wore white capri pants and a turquoise blouse that probably cost more than my monthly HOA fee. "Good morning, neighbor," she said, her voice dripping with false sweetness. "I'm Sharon Pemberton, the HOA president. I wanted to personally welcome you to Saguaro Heights and discuss a few teensy concerns." I set down my laptop bag and shook her outstretched hand. "Ryan Vance, nice to meet you. What concerns?" Her smile tightened. "Well, I noticed your garage door was left open yesterday evening until almost 8 p.m. Our community standards require all garage doors to remain closed except during active entry and exit. Also, your trash cans are visible from the street. They need to be stored out of sight at all times except on collection days." I blinked at her, processing this absurdity. My garage door was open because I was unpacking boxes and carrying them inside, and the trash cans are in the side yard, exactly where the previous owner kept them. "The previous owner received multiple violations for that same issue," Sharon replied, her tone becoming sharp. "I'm giving you a courtesy warning today, but any future infractions will result in formal fines. $50 per violation, and they compound daily until corrected." Daily. I couldn't hide my disbelief. "That seems excessive." "Those are the rules everyone agreed to when they purchased property here," she said. "I'm sure you reviewed the CC and Articus before closing." I had reviewed them, though I admitted they were dense legal documents that my eyes had glazed over after the first 20 pages. But I distinctly remembered nothing about daily compounding fines. "I'll move the trash cans, but I think we need to have a reasonable conversation about enforcement policies." Sharon's expression hardened. "Mr. Vance, I've been president of this HOA for 6 years. I know what's reasonable. This neighborhood maintains high standards, and that's why property values here are 15% higher than surrounding areas. If you have a problem with the rules, you're welcome to attend our monthly board meetings. Third Thursday of every month, 7 p.m. at the community center." She walked away before I could respond, leaving me standing in my driveway feeling like I had just been scolded by an elementary school principal. I loaded my car and headed to work, annoyed but not yet alarmed. Everyone knew HOAs could be petty. I figured if I followed the rules and kept my head down, everything would be fine. I was incredibly wrong. The first violation notice arrived the following week: $50 fine for unapproved exterior modification. The modification in question: I had placed 2 potted desert willows on either side of my front door. According to the notice, All landscaping changes required Architectural Review Committee approval, and I had violated Section 7.3.2 of the CC and Articles. I called the property management company, Desert Vista Management, and spoke with a tired-sounding woman named Linda who explained that, yes, technically even potted plants required approval, but usually the board was flexible about small items. She suggested I submit a retroactive approval form and the board would likely waive the fine. I filled out the form that evening, including photos of the inoffensive plants and a written explanation that they were temporary containers, until I decided on permanent landscaping. I emailed it to the designated address and copied Sharon directly. Her response came within an hour. Application denied. Native desert plants only. Remove immediately or face additional fines. The desert willows were native desert plants. I literally drove to a specialty nursery that focused on Arizona-appropriate landscaping. I replied with information from the nursery and links to Arizona State botanical resources confirming the plants were not only native but recommended for water conservation. Sharon didn't respond. Instead, 2 days later, another violation notice arrived. The fine was now $150 for failure to correct the original violation, and a new $50 fine for unpermitted paint touch-up, because I had covered a small scuff mark on my front door frame with matching paint from the previous owner had left in the garage. This was getting ridiculous. I decided to take Sharon up on her invitation and attend the next board meeting. The Saguaro Heights Community Center was a modest building with a meeting room that could hold maybe 40 people. When I arrived at 6:55 p.m. on that third Thursday in April, only a handful of residents were scattered across the folding chairs. The board sat at a table facing the room, Sharon in the center, a nervous-looking man in his 60s to her left who was introduced as the treasurer Kenneth Morrison, and a younger woman with dark hair pulled into a severe bun to Sharon's right who served as secretary, Brenda Patterson. Sharon called the meeting to order at precisely 7 p.m. and launched into reviewing financials and ongoing projects. She spoke quickly, referencing documents that weren't provided to the residents in attendance, and frequently used phrases like, as previously discussed, and continuing our established policy, without explaining what those discussions or policies actually were. When she finally opened the floor for homeowner comments, I raised my hand. "Yes, Mr. Vance," Sharon said, her smile returning in its fake glory. I stood, suddenly aware that every head in the room had turned toward me. "I wanted to discuss the recent violation notices I've received. I believe there's been some misunderstanding about the potted plants and the paint touch-up. I've tried to communicate through proper channels but haven't received reasonable responses." "There's no misunderstanding," Sharon interrupted. "You violated clearly stated rules. The violations stand. But the plants are native species, which should satisfy the architectural guidelines. And the paint was matching the existing color for minor maintenance, which the CC and Articles specifically allow without approval for amounts under 1 gallon. Sharon's jaw tightened. "Mr. Vance, you're new here, so let me explain how this works. The board has discretion in interpreting and enforcing the governing documents. We've determined your modifications violated the rules. You can either pay the fines and remove the offending items, or you can continue to rack up additional penalties. Your choice." "That's not how HOA law works in Arizona," I said, feeling my face flush. "Boards have to act reasonably and consistently. You can't arbitrarily enforce rules against some people and not others. Are you accusing this board of unfair treatment?" Sharon's voice rose slightly. Because I can show you our records of consistent enforcement across this entire community. I'd actually like to see those records, I said. Under Arizona HOA law, homeowners have the right to inspect association books and records. I'd like to formally request copies of all violation notices issued in the past 2 years and all architectural review decisions. The room went silent. Kenneth shifted uncomfortably in his seat. Brenda's pen had stopped moving on her notepad, frozen mid-word. Sharon stood slowly. You'll need to submit that request in writing to our management company. They'll process it according to the statutory timeline. Now, if there's no other business, there is other business, said an older man sitting 2 rows behind me. I've been trying to get approval for a solar panel installation for 8 months. Every time I submit the application, I'm told there are deficiencies, but nobody clearly explains what needs to be changed. I've spent $2,000 on engineering reports and revised plans. Solar panels create aesthetic issues, Sharon said dismissively. Your application is still under review. For 8 months. Complex applications take time, Gerald. We'll notify you when a decision is made. A woman near the front spoke up. I'd also like to know why our HOA fees increased by $20 this year, but we still have broken streetlights on Desert Rose Drive, and the playground equipment has been pending repair since last summer. Sharon's expression grew stormy. Our financial decisions are made with careful consideration of long-term community needs. If you'd like a detailed breakdown, you can request it through proper channels. This meeting is adjourned. She gathered her papers and stood, clearly ending the meeting regardless of whether anyone else had concerns. The 3 board members left through a side door while residents sat looking at each other with expressions ranging from frustrated to resigned. The older man, Gerald, approached me as I headed toward the exit. You're braver than most speaking up like that. I'm Gerald Chen, over on Palo Verde Lane. Ryan Vance. I just moved in on Cactus Way. We shook hands. Word of advice. Gerald lowered his voice. Sharon doesn't like being challenged. She's vindictive. Several homeowners who have pushed back on violations have found themselves drowning in frivolous fines and legal threats. One family actually sold and moved rather than keep fighting. That can't be legal, I said. Probably isn't. But fighting an HOA requires lawyers, and lawyers cost money. Most people eventually decide it's not worth the expense and stress. Gerald shrugged. I'm close to retirement. I've got time and stubbornness on my side, but you're young with a career. Just consider whether this is a battle you want to fight. I appreciated his concern, but something stubborn in me bristled at the idea of being bullied in my own neighborhood. I'll submit my records request and see what happens. What happened was worse than I anticipated. I sent a formal written request to Desert Vista Management the next morning, citing Arizona Revised Statutes Section 33-1805, which gave me the right to inspect HOA records. I asked for all violation notices issued in the previous 2 years, all architectural review committee decisions, meeting minutes and financial records, including detailed expense reports. Linda from the management company called me that afternoon. Mr. Vance, I received your request. I need to let you know that compiling these records will take time, and the HOA may charge you reasonable copying costs. That's fine. How long do you estimate? The statute gives us 10 business days for financial records and 5 business days for meeting minutes. The other materials might take longer to compile. But they have to provide them, correct? Linda hesitated. Yes, though the board can withhold certain privileged information. I'll let them know about your request. 3 days later, I received not the records I requested but a legal letter from a law firm called Patterson and Associates, representing the Saguaro Heights HOA. The letter accused me of harassment and creating a hostile environment for board members. It claimed my aggressive behavior at the board meeting had violated community conduct standards, and that my records request was overly broad and intended to burden the association rather than serve any legitimate purpose. The letter demanded I withdraw my records request, pay the outstanding violation fines totaling $200, and sign a statement agreeing to cease all harassing conduct toward board members. If I failed to comply within 10 days, the HOA would pursue all available legal remedies, including additional fines, suspension of my rights to common area facilities, and a lawsuit for attorney fees. I read the letter 3 times, my anger building with each pass. This was pure intimidation. I had been polite at the meeting, my records request was completely lawful, and nothing I had done constituted harassment by any reasonable definition. I needed a lawyer. After researching Arizona HOA attorneys, I found Margaret Jensen, a partner at Jensen and Schultz who specialized in homeowner association disputes. Her website featured several testimonials from homeowners who had successfully fought overbearing HOAs, and she offered a free initial consultation. Margaret's office was in Scottsdale, in a modern building with floor-to-ceiling windows overlooking Camelback Mountain. She was in her mid-40s with short red hair and an air of no-nonsense competence. She reviewed the letters and violation notices I brought, occasionally shaking her head. "This is egregious," she said after reading everything. "The violations are petty and the enforcement appears arbitrary. The demand letter is clearly designed to intimidate you into giving up your legal rights. Have they provided any of the records you requested?" "Nothing yet." "It's only been a few days, so they're still within the statutory timeline." "They won't provide them," Margaret said flatly. "Or if they do, the records will be incomplete or heavily redacted. I've dealt with boards like this before." The aggressive response to your reasonable request suggests they're hiding something. Like what? Could be financial mismanagement, selective enforcement proving discrimination, or simple incompetence they don't want exposed. Regardless, you have a strong case for improper enforcement and interference with your statutory rights. The question is whether you want to pursue it. What would that involve? Margaret leaned back in her chair. First, we respond to their demand letter making clear you're exercising legal rights and their threats are improper. We reiterate your records request and put them on notice that any retaliation will be documented. If they continue with violations or withhold records, we file suit. Arizona law allows homeowners to recover attorney fees if they substantially prevail in HOA disputes, which means if we win, the HOA pays my fees. If we win, I repeated. I'm confident based on what you've shown me, but litigation is stressful and time-consuming. Even if they ultimately pay my fees, you'll be tied up in court proceedings for months, maybe longer. You need to be prepared for that. I thought about Gerald's warning, about the families who had given up and moved rather than fight. Then I thought about Sharon's smug expression and the legal threat lying on Margaret's desk. "Let's do it," I said. Margaret smiled. "Good. Let me draft a response and we'll go from there." Her response letter was a thing of beauty. It methodically dismantled every claim in the HOA's demand letter, cited specific statutes they were violating, and made clear that I would not be intimidated out of exercising my legal rights. It also put them on notice that any further retaliation would be documented as evidence of bad faith. The HOA's response was to double down, A week after Margaret sent her letter, I received 5 new violation notices in a single day. My mailbox was too visible from the street. My house number wasn't properly illuminated at night despite being clearly visible. My driveway had excessive staining that needed to be professionally cleaned. My backyard fence had a loose board requiring immediate repair. And my exterior light fixtures didn't match the architectural style of the community, despite being original to the house when I purchased it. Each violation carried a $50 fine, and the notices stated that daily penalties would begin accruing if the issues weren't corrected within 5 days. I documented everything with photographs and timestamps, then forwarded it all to Margaret. I also started keeping a detailed log of every interaction with the HOA, every letter received, every conversation with the management company. Margaret filed suit in Maricopa County Superior Court in May 2023. The complaint alleged multiple violations of Arizona HOA statutes, including improper enforcement, failure to provide records, retaliation, and breach of fiduciary duty. We sought an injunction stopping the violations, an order compelling production of records and attorney fees. The HOA hired a larger law firm to defend the case, Barrett and Stone, and they came out swinging. Their response denied all wrongdoing and filed a counterclaim alleging I was the one breaching the CC and Artiques, and that I owed the HOA over $1,500 in accumulated fines, plus their attorney fees for having to defend against my frivolous lawsuit. The discovery process began, which meant both sides could request documents and information from each other. Margaret's requests were extensive. All HOA records, board meeting minutes, emails between board members, financial records, records of violations issued to any homeowner, architectural review decisions, and communications with the management company. The HOA's responses were a masterclass in obstruction. They claimed many documents didn't exist or couldn't be located. They produced some financial records, but with entire sections redacted as privileged. Board meeting minutes were sparse and clearly incomplete, often just a few sentences summarizing meetings that supposedly lasted an hour or more. Architectural review records were disorganized and inconsistent. Most concerning, there were huge gaps in the violation records. According to what they produced, only a handful of violations had been issued in the past 2 years, and mine were among them. But I personally knew of several other homeowners who had received violations, including Gerald. They're either hiding records or they never kept proper records in the first place, Margaret told me during a case update meeting. Either way, it's a problem for them. Arizona law requires HOAs to maintain detailed records. The deposition phase started in August. Margaret deposed Sharon first, and I attended to watch. Depositions are less formal than court proceedings but still sworn testimony. Sharon arrived with her attorney, a sharp-dressed man named Thomas Barrett who probably charged $400 an hour. Margaret began with basic questions about Sharon's role and how long she had been president. Sharon answered in clipped tones, clearly annoyed at being questioned. As Margaret dug into specific decisions about my violations, Sharon became defensive. Mrs. Pemberton, can you explain why Mr. Vance's potted desert willows required architectural review approval? All landscaping changes require approval. It's in the CC and Artiques. Does that include temporary potted plants? All landscaping, Sharon repeated. Have you required other homeowners to get approval for potted plants on their porches or doorsteps? Sharon hesitated. If we observe violations, we address them. But can you name another specific instance where a homeowner was fined for temporary potted plants? I don't keep that information memorized. Are you aware of homeowners at 423 Saguaro Drive who have potted plants that have been there for over a year? I don't inspect every property every day. Margaret pulled out photographs. These were taken last week. 8 large potted plants on the front porch, clearly visible from the street. No architectural review approval was ever submitted. Why wasn't this homeowner cited? Thomas Barrett interjected. How do you know approval wasn't granted? Because we requested all architectural review approvals in discovery, and none exist for that property for the past 3 years. Sharon shifted in her seat. Perhaps that homeowner installed them more than 3 years ago. They purchased the home 2 years ago, and the plants appear in photos from their listing when they bought it. Did the board grant approval to the previous owner? I don't recall every decision from years ago. Margaret continued this pattern for 3 hours, walking through each of my violations and producing evidence of other homeowners with similar or identical situations who faced no enforcement action. Sharon's answers became increasingly vague and defensive. She repeatedly claimed not to remember details, or that decisions were made collectively by the board, or that there were mitigating factors she couldn't recall specifically. The deposition of Kenneth Morrison, the treasurer, was even more revealing. Kenneth was clearly uncomfortable from the moment he sat down. He acknowledged that he had limited involvement in day-to-day decisions and mostly just signed off on financial reports prepared by the management company. You personally review the association's bank statements each month? Margaret asked. The management company sends summaries. But do you review the actual bank statements? Not usually. I trust the management company to be accurate. When was the last time you conducted an independent audit of the association's finances? Kenneth looked to his attorney, who nodded. We've never done an independent audit. The management company provides annual reports. Are you aware that Arizona law requires HOAs to conduct periodic financial reviews or audits? I believe the management company handles that. Margaret produced financial documents. These are the reports provided in discovery. Can you explain why there are multiple expense categories with very general descriptions and no supporting invoices? For example, legal fees shows expenditures totaling $45,000 over 2 years, but there's no breakdown of what those fees were for. Kenneth squinted at the papers. I'd have to check with the management company. You're the treasurer. Don't you track what the association spends money on? Sharon handles most of the operational details. I just make sure we're staying within the overall budget. It became clear that Kenneth was a figurehead who rubber-stamped whatever Sharon wanted. His deposition lasted less than 2 hours because he genuinely didn't know answers to most of Margaret's questions. Brenda Patterson's deposition was scheduled for early September. She was the HOA secretary, responsible for maintaining records and documenting board meetings. Her deposition would be crucial because the missing and incomplete records were central to our case. The night before Brenda's deposition, Margaret called me at 9 p.m. Her voice was tight with barely controlled excitement. I just received a call from Thomas Barrett. Brenda Patterson wants to meet with me privately before her deposition, without the HOA's attorneys present. Is that normal? It's rare. And it usually means someone is about to flip. She might be willing to testify truthfully even if it hurts the HOA's case. I'm meeting her tomorrow morning, 2 hours before the scheduled deposition. I barely slept that night, wondering what Brenda might reveal. Margaret called me right after the meeting. Ryan, get to my office as soon as you can. You need to hear this. I drove to Scottsdale, breaking probably several speed limits. Margaret was in her conference room with her partner David Schultz, both looking at a stack of papers spread across the table. Brenda Patterson just confessed to destroying HOA records on Sharon's instruction, Margaret said without preamble. Extensive records including violation notices, emails, and financial documents. I sat down heavily. She destroyed evidence. According to her statement, Sharon became concerned after we filed the lawsuit that discovery would reveal selective enforcement patterns and financial irregularities. In June, Sharon told Brenda to delete emails between board members discussing specific homeowners and violations. Brenda initially refused, but Sharon pressured her, claiming the emails were privileged board deliberations that didn't need to be preserved. "That's spoliation of evidence," David added. "It's a serious violation with significant legal consequences." Margaret continued, "It gets worse." Brenda says Sharon also told her to clean up the physical violation files, removing notices for homeowners who were friends with board members or had their violations quietly forgiven without formal action. Brenda estimates she destroyed records of at least 40 violations issued over the past 3 years that were never followed up on or were dismissed without going through proper procedures. "Why is Brenda telling us this now?" I asked. "Because she's terrified," Margaret said. She received a letter from the HOA's attorneys preparing her for the deposition, coaching her on what to say. The letter included language about potential personal liability if she failed to follow board directives. She interpreted it as a threat that Sharon would throw her under the bus if the case went badly, so she decided to come clean. Will she testify to this in court? She's willing to give a sworn statement and testify if needed. She's also providing copies of some documents she kept personal backups of, including emails Sharon thought were deleted. Brenda kept them on her personal computer because she had doubts about what Sharon was asking her to do. Over the next hour, Margaret walked me through what Brenda had preserved. There were emails showing Sharon discussing targeting specific homeowners for enforcement while deliberately ignoring violations by others. One email chain discussed me specifically, sent the day after the April board meeting. Sharon's email read, "This new homeowner, Vance, needs to learn his place. Nobody challenges this board and gets away with it. Let's go through his property with a fine-tooth comb and find every possible violation. Make his life miserable until he either complies or sells." Kenneth had responded, "Are you sure that's wise? He seemed ready to lawyer up." Sharon's reply, "Let him. We've got deeper pockets and better attorneys. He'll give up when he sees the cost." Reading those words, seeing the casual cruelty and abuse of power laid out in black and white, made my blood boil. There were also emails about the destruction of records. After we filed suit, Sharon wrote to Brenda, "We need to clean up the files before discovery. Get rid of anything that makes enforcement look inconsistent. And delete this email after you read it." Brenda hadn't deleted it. Margaret immediately filed an emergency motion with the court, disclosing the spoliation of evidence and requesting sanctions against the HOA board. She attached Brenda's sworn declaration detailing what had been destroyed and providing copies of the emails she had preserved. The motion created chaos. The judge, Honorable Patricia Delgado, scheduled an emergency hearing for the following week. The HOA's attorneys scrambled to respond, first trying to claim the deletion of emails was routine document management, then attempting to argue that Brenda had exceeded her authority and acted without board approval. But the emails proved otherwise. Sharon had explicitly ordered the destruction of records, and Kenneth had been copied on at least some of those communications. The hearing was held on a Wednesday morning in mid-September. Judge Delgado was a no-nonsense jurist with 20 years on the bench and a reputation for intolerance of attorney misconduct or discovery abuse. Her courtroom was modern, with wood paneling and Arizona state seal prominently displayed behind the bench. Margaret presented our evidence methodically. She introduced Brenda's declaration, the preserved emails, and testimony about the missing records that had been documented during earlier discovery disputes. She argued that the destruction of evidence was intentional, done in bad faith to hide wrongdoing, and warranted severe sanctions, including an adverse inference that the destroyed records would have supported my claims. Thomas Barrett tried to minimize the damage. He argued that some miscommunication may have occurred, but there was no proof Sharon intended to violate discovery rules. He claimed Brenda had misunderstood instructions and acted independently. He suggested the destroyed emails and records were likely duplicative or irrelevant. Judge Delgado listened to both sides, her expression growing progressively darker. When Barrett finished his argument, she didn't hesitate. "I've reviewed the evidence presented, including Miss Patterson's declaration and the preserved emails. The pattern is clear and deeply troubling. This court takes discovery obligations seriously, and the deliberate destruction of relevant evidence strikes at the heart of the judicial process." She looked directly at Barrett. "Your client, Mrs. Pemberton, explicitly instructed the destruction of evidence after this lawsuit was filed. That's not document management. That's spoliation, and it's sanctionable conduct." Barrett started to respond, but Judge Delgado held up her hand. "I'm entering an adverse inference instruction. The jury will be told that the destroyed records likely supported Mr. Vance's claims of selective enforcement and improper conduct. Additionally, I'm imposing monetary sanctions. The HOA board will pay Mr. Vance's attorney fees incurred in bringing this spoliation motion and conducting additional discovery necessitated by the destroyed evidence." "Your Honor, the board's finances," Barrett began, "should have been considered before your client's destroyed evidence," Judge Delgado interrupted. "Furthermore, I'm ordering Mrs. Pemberton, Mr. Morrison, and the HOA to pay, jointly and severally, $15,000 in sanctions to deter this type of conduct. These sanctions are payable to the court within 30 days. The ruling was devastating for the HOA's defense. An adverse inference meant the jury would be instructed to assume the worst about what the destroyed documents contained. And the monetary sanctions were personally assessed against Sharon and Kenneth, meaning they couldn't simply use HOA funds to pay them off without consequence." Margaret leaned over to whisper to me, "This is huge. The case just shifted dramatically in our favor." She was right. Within a week, Thomas Barrett contacted Margaret to discuss settlement. The HOA wanted to resolve the case without going to trial, knowing that the adverse inference instruction and evidence of Sharon's misconduct would likely result in a jury verdict against them. The settlement negotiations took several weeks. The HOA initially offered to drop all violations against me and pay $20,000 in attorney fees. Margaret countered with a demand for $75,000 in fees, removal of Sharon from the board, and reforms to the association's enforcement and record-keeping procedures. We eventually settled in October 2023. The HOA agreed to pay $55,000 in attorney fees, remove all violations from my record, and implement a series of reforms including mandatory training for board members on Arizona HOA law, establishment of a proper architectural review committee with written standards and appeal procedures, and hiring of a new management company with better oversight. Most importantly, Sharon Pemberton resigned from the board. Kenneth Morrison also resigned, acknowledging he hadn't fulfilled his duties as treasurer. Brenda remained as secretary under the condition that she implement proper record-keeping systems and receive training on document retention. But the story didn't end there. In December 2023, I attended my first board meeting under the new leadership. Gerald Chen had been elected president, and several other homeowners who had been vocal about Sharon's abuses now served on the board. The meeting was organized, transparent, and actually addressed community concerns rather than serving as a rubber stamp for authoritarian decisions. During that meeting, the new treasurer presented findings from an audit of the association's finances over the previous 3 years. The audit revealed significant irregularities. Over $60,000 in HOA funds had been spent on legal fees related to violation enforcement actions that were never properly documented or authorized by the full board. Another $20,000 had been paid to a landscaping company owned by Sharon's brother-in-law, with no competitive bidding and inflated invoices. Based on these findings, we're referring the matter to the Arizona Attorney General's Office for investigation, Gerald announced. This board will not tolerate financial misconduct or self-dealing. The room full of homeowners erupted in applause. The Attorney General's office opened an investigation in early 2024. While I wasn't directly involved in that process, I followed the news through community updates and occasional conversations with Gerald. The investigation expanded beyond just financial irregularities to examine Sharon's pattern of using HOA funds and authority for personal retaliation against homeowners she didn't like. In June 2024, Sharon Pemberton was charged with multiple counts of theft, fraud, and abuse of fiduciary duty. The criminal case alleged she had misappropriated HOA funds, accepted kickbacks from vendors, and used association resources for personal benefit. Kenneth Morrison was charged as an accomplice for knowingly signing off on improper expenditures. I was called as a witness during the preliminary hearing, testifying about the violations, the attempts to intimidate me, and the destruction of records. My testimony was relatively brief, but it helped establish the pattern of conduct the prosecution was building. The criminal case moved slowly through the system. Sharon hired an expensive defense attorney and fought the charges. Kenneth accepted a plea deal in exchange for testifying against Sharon, admitting he had been aware of some improprieties, but had been too intimidated by Sharon to speak up. He received probation and community service. Sharon's trial began in February 2025. I attended several days of testimony. The prosecution presented evidence of the financial misappropriation, including testimony from the HOA's accountant, bank records showing suspicious transfers, and emails between Sharon and her brother-in-law discussing inflated invoices. They also presented evidence of her retaliatory conduct, including my case and testimony from 3 other homeowners who had been targeted after opposing her. The jury deliberated for 2 days before returning guilty verdicts on 7 counts of theft, 4 counts of fraud, and 2 counts of abuse of fiduciary duty. Judge Richard Callahan sentenced her in March 2025 to 3 years in prison and ordered her to pay full restitution to the HOA, totaling over $80,000. Kenneth Morrison's testimony had been damning. He described board meetings where Sharon would decide which homeowners to target based on personal grudges, how she directed him to approve payments without proper documentation, and how she had explicitly told Brenda to destroy records after my lawsuit was filed. His testimony, combined with the preserved emails and financial evidence, painted a picture of systematic corruption and abuse of power. Watching Sharon being led out of the courtroom in handcuffs after sentencing, I felt a complex mix of emotions. Satisfaction that justice had been served, certainly, but also sadness that it had come to this, that someone had become so consumed by petty power that she destroyed her own life and hurt so many others. The Saguaro Heights HOA, under Gerald's leadership, continued to reform. They hired a reputable management company, established clear enforcement procedures with notice and appeal rights, and created a reserve fund properly maintained according to state law. Property values in the neighborhood actually increased once word spread that the toxic board had been cleaned out and replaced with reasonable people. My relationship with my neighbors improved dramatically. Without the constant threat of arbitrary violations, people felt comfortable actually using and enjoying their properties. Block parties were organized, a community garden was established in a common area, and the playground equipment was finally repaired and updated. I became friends with several neighbors who had been fellow victims of Sharon's enforcement regime. We would occasionally joke darkly about the Sharon era while barbecuing or watching kids play in the street on warm evenings. Gerald became a close friend, and I joined the Architectural Review Committee to help ensure the process remained fair and transparent. In May 2025, I received a letter from the Arizona Attorney General's office thanking me for my cooperation in the prosecution and informing me that the case was now closed. The letter noted that my willingness to stand up to improper conduct and pursue legal action had been instrumental in exposing the larger pattern of corruption. It was gratifying to read, validation that the stress and expense of fighting back had been worthwhile. Margaret and I stayed in touch. She sent me a bottle of excellent scotch after Sharon's conviction, with a note reading, "To clients who don't back down." I occasionally referred other homeowners dealing with HOA disputes to her firm, knowing she would give them honest advice about whether their situation warranted legal action. The case also attracted some media attention. A local news station did a segment on HOA abuses, featuring my story along with several others across Arizona. That segment apparently prompted legislative action. In the 2025 Arizona legislative session, new bills were introduced to strengthen HOA oversight, increase transparency requirements, and establish clearer penalties for board members who violated their fiduciary duties. I was invited to testify before a legislative committee about my experience. Standing in the Arizona State Capitol building, telling my story to lawmakers who actually seemed interested in fixing the problems I had described, felt surreal. The committee chairman thanked me for my testimony and noted that stories like mine demonstrated why stronger protections for homeowners were necessary. Several of the proposed reforms were incorporated into a bill that passed both chambers and was signed into law in July 2025. The new law required HOA boards to undergo annual training on their legal obligations, established clearer procedures for homeowners to challenge violations, mandated regular financial audits for associations over a certain size, and created a state ombudsman position to investigate complaints about HOA misconduct. It wasn't perfect, but it was progress. By late 2025, life in Saguaro Heights had settled into normalcy. My potted plants remained on my front porch without harassment. I painted my door frame whenever it needed touch-up without seeking permission for minor maintenance. The HOA focused on actual community improvement rather than petty enforcement of arbitrary rules. I ran into Brenda one day at a local coffee shop. She looked healthier than during the stressful period of the lawsuit and trial. We talked briefly, and she apologized for her role in what had happened. "I should have stood up to Sharon earlier," she said. "I kept telling myself I was just following instructions, that it wasn't my responsibility to question the president. But I knew what she was doing was wrong." "You did the right thing in the end," I told her. "Your testimony made a huge difference. I just wish I had done it sooner, before things got so bad." She paused. "I'm stepping down from the board at the end of my term. I think the association needs fresh leadership without connections to the old problems." I understood her reasoning, though I told her honestly that she had redeemed herself by coming forward. We parted on good terms, two people who had been caught up in a situation neither of us anticipated. The financial impact of the entire ordeal was significant. While the settlement covered my attorney fees, I had spent countless hours dealing with the situation, attending meetings and depositions, and living with the stress of litigation. But I never regretted fighting back. Some principles are worth defending, and the idea that I should be able to live peacefully in my own home without arbitrary harassment felt fundamental. The case also taught me important lessons about governance and accountability. HOAs are essentially small governments with the power to impose rules and levy fines. When that power is exercised without proper oversight or transparency, abuse becomes almost inevitable. The people of Saguaro Heights had essentially allowed Sharon to accumulate unchecked authority by not paying attention to what the board was doing, by not attending meetings or asking questions, by assuming someone else would handle it. We all paid a price for that collective inattention. But we also learned from it. The reformed board operated with much more community involvement. Meeting attendance increased dramatically. Homeowners actually read the financial reports and asked questions about expenditures. The Architectural Review Committee published clear standards, so homeowners knew what to expect before submitting applications. In December 2025, the HOA held its annual holiday party. It was better attended than any community event in years, with families gathering in the community center for food, music, and genuine camaraderie. Gerald gave a short speech thanking everyone for their involvement in rebuilding the association and creating a real sense of community. 3 years ago, this neighborhood was divided and dysfunctional, he said. Today, because people like Ryan Vance were willing to stand up for what was right, because Brenda Patterson found the courage to tell the truth, and because all of you got involved in making this place better, we have something to be proud of. The room applauded, and I felt genuinely moved. It hadn't been my goal to become some kind of community hero. I had just wanted to live in my house without being harassed about potted plants. But the outcome had been larger than my individual situation, affecting the entire neighborhood for the better. As 2025 turned into 2026, I reflected on the entire experience. 3 years from that first knock on my door by Sharon Pemberton to her conviction and imprisonment. 3 years of stress, conflict, legal proceedings, and uncertainty. But also 3 years that demonstrated the importance of standing up to abuse of power, the value of transparency and accountability, and the possibility of genuine reform when people are willing to fight for it. My house, the dream home I had purchased in March 2023, remained exactly that. The mountain views were still spectacular. The neighborhood was now genuinely pleasant, and I had built real friendships with neighbors who had shared the struggle to reclaim our community from a tyrant with a title and too much unchecked authority. I sometimes wondered what would have happened if I had taken Gerald's early advice and simply kept my head down, paid the fines, and avoided confrontation. Life would certainly have been less stressful in the short term. But Sharon would still be president, still abusing her power, still making life miserable for anyone who crossed her. Kenneth would still be rubber stamping questionable expenditures. Brenda would still be deleting records on command. The decision to fight back had been the right one, not just for me but for everyone who lived in Saguaro Heights. And while I hoped I would never again have to file a lawsuit to live peacefully in my own home, I knew now that I was capable of it. That standing up to bullies, even bullies with official titles and legal threats, was possible and sometimes necessary. On a warm evening in February 2026, almost exactly 3 years after I had moved in, I sat on my front porch with those controversial potted desert willows on either side of the door. Gerald stopped by with his wife, and we shared a beer while watching the sunset paint the mountains in shades of orange and purple. "You know what I never asked you," Gerald said. "Do you regret buying here? After everything that happened?" I considered the question seriously. The stress had been real, the conflict had been exhausting, and there were definitely moments during the darkest parts of the litigation when I had questioned whether any house was worth this much trouble. "No," I finally answered. "I don't regret it. This is my home." And fighting to protect it taught me something important about standing up for what's right, even when it's difficult. Gerald raised his beer bottle in a toast to standing up for what's right. We clinked bottles and drank as the sun disappeared behind the mountains, leaving the desert sky streaked with color. In the distance, I could hear kids playing and the sound of neighbors talking and laughing in their yards. It was the sound of a healthy community, one that had been broken and then rebuilt stronger. The whole ordeal had taught me that HOAs, like any form of government, are only as good as the people who run them and the citizens who hold them accountable. Sharon Pemberton had turned a homeowners association into her personal fiefdom, using rules and regulations as weapons against anyone who challenged her authority. She had stolen money, destroyed evidence, and ruined the lives of numerous homeowners who simply wanted to live peacefully in their homes. But in the end, the system worked. When I refused to be intimidated, when Margaret pursued the case aggressively, when Brenda found the courage to tell the truth, and when Judge Delgado held Sharon accountable for destroying evidence, justice prevailed. Sharon went to prison, the HOA was reformed, and the community was restored. The attorney fees awarded by the court sent a clear message that homeowners have rights and boards that violate those rights will face consequences. The sanctions imposed for destroying records established that courts won't tolerate spoliation of evidence. And the criminal prosecution demonstrated that being elected to an HOA board doesn't grant immunity from the law. As night fell over Saguaro Heights, I felt genuinely content. The journey from that first confrontation with Sharon about garage doors and trash cans to her conviction and imprisonment had been long and difficult, but it had been worth it. My home was truly mine now, free from arbitrary harassment and petty tyranny. And somewhere in an Arizona prison, Sharon Pemberton had 3 years to reflect on how abuse of power, destruction of evidence, and theft from people who trusted her had consequences. The woman who had once threatened me with daily compounding fines and legal action now faced daily reminders that she had destroyed her own life through greed and vindictiveness. I didn't take pleasure in her suffering. I would have much preferred that she had simply been a reasonable HOA president who enforced rules fairly and managed the association responsibly. But since she had chosen instead to be a tyrant, I was satisfied that she had been held accountable. The lights of Phoenix glittered in the distance as darkness settled over the desert. Inside my house, unchanged except for those potted plants that had started everything, I had built a good life. The nightmare of living under Sharon's HOA regime had ended, replaced by the normalcy of a well-functioning community association. I finished my beer and said goodnight to Gerald, heading inside where I belonged. Tomorrow I had work, normal everyday concerns, a life free from legal battles and HOA drama. The fight was over, won decisively. The records Sharon had destroyed couldn't save her. The judge had sanctioned the board heavily. The attorney fees had been awarded. And justice, after a long and winding journey, had been served. 3 years after moving into my dream home in Phoenix, Arizona, I could finally just live there in peace. And that, more than any legal victory or criminal conviction, was what I had been fighting for all along.